Hello, everyone. Welcome to Court with Krissy. It doesn't matter the internet connection. This tenant is a total Karen. I've got back-to-back appearances, so make sure you stick around for the second one, where it goes downhill. I hope you like it. Court with Krissy is now in session.
All right, the court will recall the matter of Equilibrium Management versus Michael Workman and Faye Kamoosh. That's file 26-41827-L. Council, have the parties reached an agreement?
Water.
Unfortunately, Your Honor, we have not.
All right, Ms. Kamoosh and Mr. Workman, how would you like to proceed?
Jury, please.
I agree with my dog.
My father agrees. He said he had a stroke 30 years ago.
All right. Are you going to be prepared to move this matter forward in front of a jury?
That's what I just said, Your Honor.
Yeah.
Have you done something like that before so that you know what is coming?
I'm well versed in the litigation process, Your Honor.
All right, thank you. I just want to make sure. All right, we'll set the matter. Prior to the jury trial, we'll set a last settlement conference. 1 week prior. At that last settlement conference, the parties will submit proposed jury instructions. They must talk to each other and submit one set. I'm not going to have jury instructions from both. They will be able to argue about any jury instructions that are not agreed upon at a settlement conference the week before. So the jury instructions will be in 14 days in advance. There'll be a witness and exhibit list 14 days in advance, and any evidentiary issues will also be noticed and heard at that last settlement conference, and they must be submitted 14 days in advance as well. Either party have any questions as to the court's order?
No, Your Honor.
No, Your Honor.
All right, the court will set a pretrial order with those requirements in place and with a copy of the notice for jury trial to be set by the court. Now, if the parties have not received anything in the next 7 days, please recontact the court to make sure that it wasn't mailed to the wrong place. Ms. Kamoosh, I have you at, is that correct?
Yes, Your Honor.
And Ms. Whitty in Kalamazoo Street in Lansing?
Yeah.
All right. The jury trial will be in person. So parties and witnesses will need to be in person for the jury trial. Any questions that anybody has?
No, thank you.
No.
Thank you.
All right. That's all for today then. Thank you very much.
Thank you. Have a great day.
Yeah,
You too.
Bye.
Equilibrium Management, Faye Kamoosh and Michael Workman, file 26-41827-LT.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff, Equilibrium Management.
Ms. Kamoosh, were you trying to talk to me earlier in today's proceedings?
It was me who spoke, yes, if that's what you're
Do you understand that it's not your place and time to speak unless it's your case? Still there, Ms. Kamoosh?
No, however, I've been in this courtroom many times and observed, and I observed some systemic there's some concerns in this county I'm seeing. So anyway, I think we can proceed with the case so that I can get out of this county, quite frankly.
The question was, do you understand it's not your place to speak in the courtroom unless it's your case? Do you understand that now?
I understand it now, sure.
All right. we were here originally in February. Parties were placed into a breakout room, no agreement was reached, and a request for a jury trial was made. The parties were told that we would set this matter for a settlement conference 1 week in advance of the jury trial once the written request was made. No request was made, so a status conference was set for today's purposes. Ms. Carmouche, are you asking for a jury trial or a bench trial, or is there some agreement that you've been able to reach with the other attorney?
I have able to reach attorney or the landlord.
I'm sorry, I'm not able to, Ms. Carmouche, I'm not able to hear you.
In that question. Understanding the redundancy of some written requests where I requested in like
Ms. Carmouche, you're breaking up
it
very
was made
badly.
verbally in court on record. I'm where I can be with the service I have to offer. You know, because again, if I could be there in person to handle this, I would be. But this is the nature of it. So are you gonna? It's what I have. So we can reschedule if the connection's not great. That's all I can do.
The question is, do you want to have a jury trial? If you do, you have to ask for it in writing, and there is a fee to be paid for it. Or do you want to have a bench?
My understanding, Your Honor, of the law is that the request is made in the courtroom and that bypasses the written request. And I will pay the jury fee. It just occurred. I wouldn't. I played requested in the courtroom, and he received the immediate correspondence that was due after the request. I requested it in the courtroom. There's no need for me to follow up with a written request. It's on record.
Ms. Carmouche, there is a requirement for a written request for a jury trial. If you wish to have a jury trial, you'll need to make a written request and pay the appropriate fee. You will have 7 days from today. You will have 7 days from today to do so.
Okay.
The next request by counsel is, while we're waiting for a jury trial to be set, is for, I believe, escrow payments of the rental payment. Counsel, do you want to make your arguments on that?
Thank you, Your Honor. Yes, at this time, we think it's appropriate for the court to order escrow of rent. We're now many months past just the pretrial date, and I think part of the reason was that jury demand wasn't properly filed and the fee wasn't properly paid, so the court kind of was in limbo. But we're incurring rent at the rate of $1,100 a month. So at this point in time, we're now at the point where there's over about $5,600 in rent plus court costs. Prorated rent through today's date would be $709.68. We think it's appropriate for that rent to be escrowed going forward, especially considering the fact that we're this far into the case and we don't even have a jury date set yet. And so we would request that the court enter an escrow order requiring the defendant to escrow rent until the time of trial.
Specifically, again, Mr. Whitty, what amount are you asking to be escrowed?
So we would request that the normal monthly rent of $1,100 a month be escrowed. My understanding is, of course, the court would prorate that rent through today's date, or it's commencing today. So prorated rent starting today for the month of May would be $709.68. So the initial escrow amount would be $709.68, and then monthly going forward at $1,100 a month.
Ms. Carmouche, do you have a response to that?
It looks like they dropped you.
We have them in the waiting room.
Yeah.
All right, we'll give them a couple minutes to see if they're able to return, and then we'll go from there, Mr. Whitty.
Thank you.
The end.
Well, I feel that's the thing.
Ms.
No, they're
Carmouche,
trying
you
to.
back
It's
now?
Stupid.
Ms. Carmouche,
No,
can you hear the
I'm
court?
even from it.
Ms. Carmouche, can you hear the court?
It's funny because I'm active.
Ms. Carmouche, can you hear the court? Almost had her back. We'll give it one more minute and see if she can make it back in.
Hi.
All right, Ms. Carmouche is back. Ms. Carmouche, were you able to hear the request of the attorney for escrow payments of rent?
I believe so, and I'm up to speed because I did receive a notice of hearing on plaintiff's motion for escrow. I did send them a response to that. It may not have gotten them to them until today. So, but my response to that is that I actually have been putting rent into escrow. That account has at this moment, it's on the letter that I sent, $7,500 in it to cover the balance. To my knowledge, right now is somewhere around 6,076, but there's $7,500 in it to cover whatever late fees might accrue. Or so I've been doing that already. I can follow the court's order for escrow and move it if net or pay the court directly. However, I feel more comfortable keeping it in a private institution than paying the court, honestly.
Mr. Whitty, what do you want to do about where the escrow is kept at?
Yeah, I'd be much more comfortable if the court held the money.
Ms.
I think
Carmouche,
that's
is
what
there
the
any
court
problem?
ordered.
I can
Okay,
submit the statement. I can submit the statement. My qualms with the court holding the money is that I do not trust that those funds will be held appropriately.
What is your basis for believing that the court's not going to hold the money appropriately?
Because my data assessment for a very prolonged period on this county is that it's quite the money pit.
Specifically, what is your assessment of the court system and what is your basis for that assessment?
Do you want to go down that road? Can we talk about entrapment of people? And there's a number of things I've observed in this county that have been very concerning. So we need not have
Entrapment,
that conversation
Ms.
here. I'd be happy to
Carmouche?
have it on a private.
No.
But I can
making-
pay the court
no,
directly. But
you're making
here's
allegations
what I'm
against the
saying is that
court.
I can
What is your
offer a
basis for
statement.
belief? What is your basis for believing that the
I
court
don't
would
think I
not
have to communicate
appropriately
that,
keep your
sir.
money?
I'm gonna withhold my Fifth Amendment right to communicate my belief systems on that currently, just so that I don't incriminate myself further.
You only have a Fifth Amendment right when there are criminal sanctions appropriate. None of the statements that you're making right now have anything to
Actually,
do
as
with
an
a crime.
American, I have a right to remain silent at any moment. Are you not familiar with Black's Law? Did you go to school, sir?
The Fifth Amendment applies to criminal proceedings. It does not apply to civil
The Fifth Amendment
proceedings unless there is a
applies to civil
potential for
rights.
criminal liability.
Freedom of speech is a civil right, sir.
Freedom of speech that's under the First Amendment. The
Right, and the freedom.
remaining
Well, my
silent is under the
speech under
Fifth
the Fifth
Amendment.
Amendment.
The Fifth Amendment
And I'm
and the
gonna do
First
so now.
Amendment are entirely different things.
And okay.
So, Ms. Carmouche, do you have any other reasons why you would not wish to place the money in escrow with the court?
I feel that I will continue to just go back and forth. So I can submit that I will follow the motion, which is that I will keep the sum up until the motion in that private account just for those reasons. But it says prorated rent from the date of the order on, I think it was 4/23. 745.08, and then 1100 per month. I can put that to the core, moving forward for escrow, if that's how you would like to proceed. But the remaining
Counsel-
funds that are past due to the point are also in escrow, I guess, is what I'm trying to say.
Thank you. I appreciate that distinction. Counsel, your proposed order with your motion said $745.08 prorated. Do you wish me to change that to $709.68?
Yes, Your Honor. I mean, that number was a number that we had when we filed the motion. Today, the number is 709.68.
Your Honor, I'm also concerned about another matter. I'm not sure if I should bring it forward now or if it's going to come up later, but I do think it's relevant.
I don't know how I would know if it's relevant because you haven't said anything yet and you haven't filed anything in writing as is typically.
Okay, so I'm waiting for your okay, but I received recently a demand for possession due to health damage, health and hazard to property. The very property that I'm proclaiming is hazardous to health. So they're proclaiming a demand for possession for that, but under the explanation as for their right to do so. Now here's the thing: I've not spent. Father and I, we're currently out. I'm traveling for work. I'm not trying to spend time there. There are notes in my response to the motion as to why. Now, all that to say, the explanation given to me in this demand for possession is that supposedly me, the defendant, this is a terrible allegation. It needs to be on record that it is absolutely absurd. The defendant attempted to hire someone to kill Cole Musel, Equilibrium Management, and his family. And that is absolutely, I was questioned by state troopers. I was flabbergasted that would even come up. I'm not sure what sort of weird family dynamic this is that I've come across, but I do know that since this has transpired, multiple vehicles on the property that I live, that this in question, have been vandalized. Not one of those people used in court.
Ms. Carmouche,
I
hang on.
witnessed
Ms.
it.
Carmouche, please wait.
This is getting out of hand.
Ms. Carmouche.
This is getting out of hand, Your Honor. That's a very serious
Ms.
allegation.
Carmouche, stop. What you're bringing up has absolutely nothing to do with what's in front of me today. If you wish to file a motion, just like Mr. Whitty did, you must do so in writing so that both sides and the court are prepared to deal with your issue. I can't solve all your problems
I understand that.
today. So if you wish to bring a motion in the future, you may do so. If you wish to have a jury trial on this matter, you have 7 days within which to make that request in writing and to file the $50 motion fee. If you fail to do that, this will be set for a bench trial. In the meantime, I'm granting Mr. Whitty's and plaintiff's motion in order for escrow. That will be the sum of $709.68 prorated for May, the sum of $1,100 per month going forward until the day of trial. Mr. Whitty, do you have any additional questions or requests for the court?
Nothing further, Your Honor. Thank you.
Ms. Carmouche, is there anything else for the court today?
No, thank you. And again, I've had some frustrations with the connection mostly, and I think that's why I've come in a little heated today. So I apologize. So anyway, thank you.
I apologize. Thank you very much. I appreciate that. That's all for today.
Yep. Bye.